My name is Jill Norcross, and I'm the Executive Director of the Northern Virginia Affordable Housing Alliance, Navaja. And just want to welcome you on behalf of Hannah Matuda, our Director of Policy and Programs, and our growing Navaja team here today. We get a lot of questions at Navaja about fair housing and about screening in for affordable housing. So we're really excited to have experts in the field join us today. We're really fortunate to have Navaja board member and leadership council member Hillary Chapman, who's the housing program manager for the Metropolitan Washington Council of Governments, to kick off the topic and to explain to us why fair housing is so important. Hillary really led the work on the Regional Fair Housing Plan through COG, where she coordinated all of the local governments in our DC metro area. And it was truly a heavy lift and labor of love, but it was so important that we could address this issue as a region. So want to commend her on that. And then she will turn it over to Brian McKenzie, who's the Director of Training and Compliance for the Equal Rights Center. And Brian, you are such an expert in the field, and we're thrilled to be able to learn from you today. So without further ado, I'll go ahead and turn it over to Hillary. Thank you for being with us, Hillary.
Well, thank you so much, Jill, for that very kind introduction. And thank you to Navaja for the opportunity to be here with everyone today to learn about fair housing and tenant screening. And as Jill noted, I had the privilege of working with 8 local governments and a group of regionally focused nonprofit organizations, including the Equal Rights Center, who work with residents in protected classes to submit a regional fair housing plan for the Washington region in 2022. And it was the first one the region has created since 1997. For those of you who may not be familiar already, the jurisdictions that participated in the process included in Northern Virginia, the city of Alexandria, Arlington County, Fairfax County, Loudoun County, and Prince William County, plus the District of Columbia, Montgomery County, Maryland, and the city of Gaithersburg, Maryland. And you may be wondering what a fair housing plan is and why it matters to have one, let alone why any one city or county should work with its neighbors on such a plan. So a fair housing plan, also known by its wonkier name, Analysis of Impediments to Fair Housing Choice, is a plan for local governments and public housing authorities to take meaningful actions to overcome historic patterns of segregation, promote fair housing choice, and foster inclusive communities that are free from discrimination. And the key components of this plan include a robust community participation and comment process, assessment of past goals and actions, analysis of data and issues that impact fair housing, and establishment of measurable fair housing goals and priorities, both local and regional. And the key is tying what we've learned from discussions in focus groups, interviews, surveys, community meetings, and from census data, and taking action based on that information to achieve the dual aims of the Fair Housing Act. And those goals are actually twofold. It's both eliminating discrimination in housing and reversing patterns of segregation. So why would these local governments collaborate on a regional fair housing plan, and why does it matter to the future of our communities here in Northern Virginia? First, working in a coordinated fashion across the region strengthens each individual jurisdiction's ability to achieve and sustain its goals regarding housing opportunity and growing, thriving, integrated, mixed income communities. In our interconnected region, many people live in one place and work in another. Second, more importantly, we cannot control what happens in our neighboring jurisdictions, but with coordinated regional action, we are able to design a plan using strategies that acknowledge, incorporate, and help shape the residential housing patterns and housing markets in our communities, which do not always neatly conform to legal boundaries. The 8 governments and nonprofit community advisory committee members landed on 7 shared regional goals. Each jurisdiction has additional goals specific to its context, but all governments have agreed to align their federal housing resources in a way that furthers our shared aims. This is a significant milestone for our region and sets it apart nationwide from other jurisdictions which have not chosen a shared path forward. I'm not going to review all of the goals and strategies, but I would like to highlight a few. Our first 2 regional goals address the lack of affordable housing as a barrier to fair housing choice. and the geography of the affordable housing available across metropolitan Washington. The single most persistent and challenging obstacle to fair housing choice is a lack of affordable housing. This prevents individuals and families from being able to live near transit with access to job centers and high-quality schools. It pushes lower-income residents into areas that may have higher environmental risks or longer commutes to work. The fact that our communities look the way they do is the result of prior government policies and practices that were designed to be exclusionary for people of color. That's why our regional fair housing plan includes a goal to not just increase the amount of affordable housing, but also to create it in communities which have historically excluded it, which means, generally speaking, lower density, single family only residential neighborhoods. Reducing barriers to housing for persons with disabilities is a challenge in our region and is one of the most common causes of fair housing complaints, not just locally, but nationally. Ensuring that we create more opportunities for persons in protected classes to access housing in the places that best meet their needs is just one part of the multi-pronged approach to increase housing equity in our region, however. And it takes not just proactive efforts to create and preserve existing housing, but also efforts to ensure access and compliance with the Fair Housing Act. That is why in our goal to increase community integration and reduce barriers for persons with disabilities that we included increasing outreach, enforcement, and fair housing testing to both educate and ensure that all housing providers are providing equal access and opportunity. While the Regional Fair Housing Plan is concerned with the goals and strategies needed to reverse the trend of increasing segregation by race and income at scale, it's the work of organizations like the Equal Rights Center, as well as informed housing providers, partners, and neighbors in communities across the region that will help guide us on the ground to getting closer to our shared goals. As we know, housing is a foundational aspect of our lives. Ensuring that all residents in our region live in integrated, welcoming communities with access to transit, good schools, and job centers supports our goals for lifetime health and well-being, reduced greenhouse gas emissions, transportation system performance, and economic growth. I'm thrilled to be here with you and Brian McKenzie from the Equal Rights Center, who'll be able to provide a local on-the-ground perspective. This work is central to ensuring that our actions on the ground support our coordinated efforts to expand access to opportunity and housing so that all residents can choose to live in a community where they can thrive. Thank you so very much. And I'm going to now hand it back over to Brian. Thank you.
I do want to thank everybody right off the top, especially Jill and Hillary for the kind introductions and Hannah for managing all of the logistics. And I'm so happy to be here with Navaha today. So thank you again for having me. My name is Brian McKenzie, and I'm the Director of Training and Compliance at the Equal Rights Center. I'm going to share my contact information here right off the bat in the chat, just in case you want to take that with you here today. Slides are going to be distributed after the training concludes. And so I do encourage you to ask questions, use the chat. We are going to cover a lot of ground today. I know we have a lot of various levels of sort of fair housing expertise. So hopefully there'll be something for everyone here during our time together. So I do need to provide one big disclaimer here, especially since this is being recorded. And that is that I am not an attorney. So nothing you are hearing today should be considered legal advice. If you do ask a question that does sort of go into legal advice, I'll probably demur from being able to answer it, but I will hopefully be able to guide you in the right direction or put you in touch with somebody that is able to assist. So, with all of that being said, we're here today to talk about tenant screening and the Fair Housing Act. And so, in particular, we're going to be talking about three big areas with regards to tenant screening: the use of credit, the use of evictions, and the use of criminal records and criminal record screening policies. First, though, we're going to go into just sort of a brief overview of the Fair Housing Act. We'll talk about protected classes and also some source of funds protections here in Virginia as well. That also involve income and tenant screenings for income checks as well. So, welcome again, and my name is Brian. Happy to be here with you today. I'm here today on behalf of the Equal Rights Center. We're a civil rights organization that identifies and seeks to eliminate unlawful and unfair discrimination in housing, employment, and public accommodations around DC, and we do nationwide work as well. I always like to remind folks when they attend, our trainings really in any capacity, that hey, these laws that we're talking about really do protect every single one of us where we live, where we work, and when we are out in public. Okay, so let's start with a brief definition of what the Fair Housing Act is, or what fair housing is. Fair housing can be defined as the sale and the rental of housing free from discriminatory practices or policies while continuing to treat everyone equally and with respect. Fair housing is important for a number of different reasons. We always say first, hey, it is absolutely the right thing to do. Secondly, yeah, it is civil rights law. When something is an act, hey, yeah, the Fair Housing Act is a law, so there are consequences. Providers need to follow the law. We also argue at the Equal Rights Center that fair housing is a smart business practice. In today's day and age, when a housing provider has a discriminatory policy, a discriminatory practice, word is going to get out, whether it's through social media, news stories, etc. People do find out about these practices, these policies, and the public finds out. The Fair Housing Act was signed into law on April 11th, 1968. Since then, it really hasn't changed that much at the federal level, which is really why local governments, state protections, state governments, local governments are all so important. Because really, those are the main jurisdictions that are expanding fair housing rights on a more regular basis. And we'll talk more about Virginia protections here later on today. So the Fair Housing Act, as you see, was signed into law on April 11th, 1968, which is exactly 1 week after Dr. King was assassinated in Memphis, Tennessee. Dr. King was assassinated on April 4th, and the Fair Housing Act is passed exactly 1 week later as a tribute to the legacy of Dr. King, support of the open housing movement, but also as a reaction to protests, to demonstrations that were going on across the country during that week as well. So we got the Fair Housing Act on April 11th, 1968. Let's now figure out who is or who is not covered when we talk about fair housing. So this usually seems fairly specific, but the Fair Housing Act applies to a number of different people in a number of different ways. Of course, people who have been discriminated against are protected, but you can actually be harmed, quote unquote, a number of different ways. For example, real estate agents can be protected. If a real estate agent is hired to show off a condo unit and the seller wants to engage in a discriminatory practice, yeah, that real estate agent could be protected. Friends and family members can be protected. Sometimes our testers, our secret shoppers can be protected. And then staff members are also protected as well. If a staff member or a leasing agent reports a discriminatory practice and says something's going on, and then they're fired or they're suspended for it, well, that is going to be sort of a whistleblower protection. So the Fair Housing Act covers a wide variety of different people in almost any living situation. Apartments, condominiums, emergency shelters, transitional housing, single-family housing, college dorm rooms, mobile home parks, nursing homes, assisted living facilities, and even vacant land designated for residential construction could be protected by the Fair Housing Act. So yeah, the FHA even applies to vacant land. So even where there's no house, the Fair Housing Act still could apply. There are exemptions to the Fair Housing Act. I am not going to go in depth into this here today. I would just flag for you, if you happen to be a small landlord, know a small landlord, there are oftentimes these small landlord exemptions. You do need to make sure you know your local law. These are just generalized right here. So sometimes, for example, a landlord who owns 3 or fewer single-family homes, yeah, they may be exempt from the FHA. Most of these exemptions apply until you hire a real estate agent or you make a discriminatory statement, which does include advertising. So again, I don't think I'm going to go more in depth into this here today. I'm happy to answer any questions around sort of Fair Housing Act exemptions, but just be aware they exist. If you're a small landlord, make sure your advertising is on point and in compliance with local fair housing laws and best practices. Okay, So we can define a protected class as a group of people who share a common trait, a common characteristic, and are then legally protected from discrimination on the basis of a trait or characteristic. So when we start talking about fair housing at the federal level, there are going to be 7 protected classes. So these protected classes apply everywhere. I know we're here for representing Virginia today, but these laws would apply in Maryland, Washington, D.C., or Alaska. These 7 protected classes really always apply unless, again, one of those exemptions that we just discussed is at play. So I know we're all eating our lunch here today, so hopefully a few of us have free hands. Let's see if we can enter into the chat here. What are some examples of a protected class when we talk about fair housing? What may be some examples? Race, disability. Yeah, I see a few folks here with good suggestions. Religion. I saw a couple references to age. I'm going to talk more about age in just a minute, but age is not necessarily a federal protection when we talk about fair housing. Yeah, family status. Okay. National origin. Cool. So we've got most of them here. Yeah, so our big 7 federal protections when we talk about the Federal Fair Housing Act are going to be race, color, national origin, religion, sex, family status, and disability. So really, not much needs to be added when we talk about these 7 protected classes. For example, I will just add a few bits of context here, though, to a few of them. National origin refers to where you and your family are from. Color. Color is going to be a protection in addition to race or national origin. People tend to use all of those phrases incorrectly and interchangeably sometimes, but you could have 2 people who share a common race, share a common national origin, and could be treated completely differently, and it would be because of the color of their skin. Religion. When we talk about religion as a protected class, we want to remember there is no exhaustive list of religions. And also, religion includes the lack of religion as well. Sex discrimination has been expanded here at the federal level a few years ago. So, sex discrimination, treating someone differently because of their sex or gender, now also includes protection based on sexual orientation and gender identity as well. So, again, we may not see those under our federal protections, but they are now included under the protections for sex discrimination. Family status. So, family status is one that can often be sometimes confusing for folks because I think the word family throws people off. When we say family status, the parental structure, the marital structure has nothing to do with that family or that reference to family. Family status really applies to families with children under the age of 18 and pregnancy. So it does not matter if it's a single mom, single dad, a married couple, an unmarried couple. It's really, again, just referring to families with children under the age of 18 and pregnancy. And then we have disability there as well. Disability is where we get things like reasonable accommodations, reasonable modifications, emotional support animals, assistance animals, all of that sort of thing when we talk about fair housing. Out of these 7 protected classes, disability is actually the number 1 protected class in terms of complaints filed. So please keep that in mind. Really, in almost any jurisdiction now, disability has become really the number 1 protected class when we talk about complaints. Also, keep in mind, hey, we do have additional local protections in our area. It is always up to everyone to know what is protected in your area. Uh, yeah, and so you could have up to 4 different layers of protected class. We'll always have the federal. Then you could add state law. Then you could add county law. And you could add a city or a town law in as well. So again, this can get, hey, really tricky when we live in jurisdictions that are so really interconnected and so regional. And I think that's just important to remember is, hey, these jurisdictions, these protections can change really quickly in our area. Keep in mind, we are going to talk about source of income in just a second, or source of funds as it's known in Virginia. That is now a protected class region wide. Virginia, Maryland, and DC now all do have additional protected classes, folks. So I am going to run through Virginia's protections here today. If you do work in DC or in Maryland, feel free to reach out to me. I can always send you their protections as well. I've shared my email in the chat. In Virginia, we expanded our protected classes now to include a few different things. So, elderliness has been a protection for a while in Virginia. Elderliness is going to be referring to individuals who are 55 and up. Sexual orientation, gender identity are protected as well. And then we have military status and source of funds. Source of funds in Virginia is really just going to be source of income, and we're going to go really kind of in depth into source of funds in just a minute. Arlington County, we have marital status and sexual orientation. Falls Church, we have marital status. Alexandria has age, ancestry, gender identity, marital status, and sexual orientation. Fairfax County has marital status, and Prince William County has age or marital status as well. So those are sort of a quick overview of our Northern Virginia protections. Does anybody have any questions around any of these Northern Virginia protections? Loudoun County does not have any protections, last I checked. So unless that has changed really recently, these are, yeah, sure, Gina. Yeah, military status. So military status is, of course, a very important protection in this region because of the number of service members that we have and veterans. And so military status can be thought of as protections for a couple of different reasons. First, there are stereotypes around military members. Think about PTSD, and I think this would also be related to disability as well. And so military status is going to protect anyone who may be disqualified because they're a member of the military. Also, we just had a case around this, but we had a landlord who was refusing to rent to members of the military. And it wasn't because of a stereotype or anything like that. It was because the landlord was concerned that somebody who was serving in the military would get called back into active duty and would be forced to break their lease. So really, it covers that sort of thing. The difference between age and elderliness. Well, yeah, that is going to be generally because elderliness in Virginia does not protect all ages, whereas most other folks, for example, DC protects age. Age applies pretty evenly across the board. So somebody should never be disqualified in Washington, D.C. because they're a particular age. And elderliness is, of course, going to protect only people who are 55 and up. I think a lot of times also that is advertising at play as well. You think about perfect for young professional, perfect for mature older couple. All of those indicate a certain age preference. And then before we go on here, looks like I have two different questions that I think I do want to address as well, which is why do all of these local areas have their own protected classes, or marital status being a statewide protection, in addition to all these different jurisdictions? Well, that's a great question. And I think right off the bat, it's because if we think about how oftentimes change starts at the local level. So, for example, a law passes in a city first, and that law does well. And then all of a sudden, the state adopts it, etc., or the county adopts it, and then the state adopts it. And then you see at the federal level, really, we haven't updated our protected classes in a while. And I think that's because oftentimes the federal government is a little, it's much harder to pass things at the federal level, as you see. So, yeah, I think really what you see here is a reflection of where things start. So, marital status, for example, got cited. Marital status, is protected in a state, and then yeah, oftentimes a jurisdiction passes it first. Um, so sexual orientation, gender identity are two good examples of that, where they passed in a jurisdiction like Alexandria, then just a couple of years ago got added at the state, and now are added at the federal level as an example of sex discrimination. Also, it is a oftentimes a matter of choice as well for the person who may be filing a fair housing complaint. These jurisdictions also have their own civil rights commissions, oftentimes. So basically, as well, somebody could file a complaint in a jurisdiction where that protected class is present. So it gives people the choice of where they can file the complaint, and it's also just sort of reflective of the political process as well. Okay, so I want to do a quick overview here of source of funds because source of funds, income checks are really probably, along with evictions, the most common example of tenant screening and how tenant screening may be involved with fair housing. Because I do want to say here, in our world and sort of in the housing world, it's sort of tricky sometimes to navigate. A lot of people lump fair housing and tenant landlord stuff together, and we actually do very, very separate things. There's different laws that guide the tenant landlord relationship and fair housing. So oftentimes I don't actually get to talk about tenant screening in my day-to-day work. But recently, when we talk about things like source of income, credit checks, evictions, and some other examples of tenant screening, there has become sort of this increasing overlap with fair housing law. And so source of funds is really a great example to start. So when we say source of funds, what we're referring to is really source of income in other jurisdictions. And what that means is any legal form of income should be considered when determining whether or not an applicant is qualified to rent from a housing provider. So, what are legal forms of income? Well, payments from federal or local government programs, rental subsidies or emergency assistance, rapid rehousing programs, veterans benefits, disability benefits, unemployment insurance, permanent supportive housing, and also, of course, housing choice vouchers. So, commonly known as the Section 8 program, the voucher program was created to certainly give people the opportunity, as Hillary talked about earlier, to move to different areas, different neighborhoods that may have increased access to better schools, green spaces, healthcare options, etc. Only what sort of local governments found when working with housing choice vouchers was that landlords simply declined to take a voucher. So local areas started to add source of income protections to essentially provide better mechanisms for the Section 8 program, for the Housing Choice Voucher program to work, and ensure that these recipients have the opportunity to move to an area that fits their family, them and their family's needs. So we really see source of income discrimination occur a couple of different ways. First, I would really highlight language. So language that I would say language first with regards to folks who say no Section 8, no vouchers allowed. All of that right off the bat is going to be discriminatory language in most jurisdictions. Virginia does have a carve out for small landlords in Virginia, where essentially a small landlord is not forfeiting their exemption by hiring an agent or making a statement. So unfortunately, we do still encounter that in Virginia because source of income does only apply to, or source of funds in Virginia only applies to these larger housing providers that meet that criteria of 4 rental dwelling units or more, or over that 10% interest in more than 4 rental dwelling units. Virginia, the other unique thing is 15 days for that source of funds to be approved is the requirement for holding that property. So again, source of income, source of funds in Virginia, a couple of unique things there with regards to the size of the housing provider that this protection applies to, and then also that weight as well. So we talked about language being the first thing that goes wrong, is a landlord who says no Section 8, no vouchers allowed. The next area that probably comes up most frequently is the use of minimum income requirements as they apply to voucher holders. So a landlord who tends to screen out based on income. So again, income is a really common screening measure that housing providers use. And housing providers can still use minimum income requirements as it relates to a voucher holder. The key phrase in Virginia, though, is that it needs to be based on an applicant's portion of the rent. Okay, folks? So on an applicant's portion of the rent. So a really frequent example is a landlord says you need to make 3 times the monthly rent to qualify for the unit. So if we keep this math really, really easy because it's lunchtime, $2,000 a month for a rental unit, that would be $6,000 a month or $72,000 a year to qualify for that apartment. The key phrase in Virginia, though, is that it needs to be based on an applicant's portion of the rent, folks. So if we have in our example here that $2,000 apartment, and the ratio comes down to the renter contributes $200 a month, the voucher covers $1,800 a month. Well, 200 times 3 is going to be $600 a month or $7,200 a year. And that person, in all likelihood, if your apartment is below the payment standard or below the rent reasonableness rate, that person is going to income qualify. So really, that is one reason Washington, D.C. does no longer allow for minimum income requirements to be used. So I do want to highlight, I know how regional everything is here. Minimum income requirements can only be used in Virginia and Maryland and not in Washington, D.C. And if you do use minimum income requirements, it should always be based on the applicant's portion of the rent. Okay, so let's jump now into a couple of other key issues with regards to tenant screening and discriminatory bias. In particular, we already talked about income. Now we're going to talk about credit, evictions, and criminal records. Okay, folks? And this is in the result of really a couple of different things that the Department of Housing and Urban Development has focused on over the last couple of years. And that's really because these three policies, these three practices, have been seen to have a disparate impact on members of a protected class. Disparate impact is, I know it's sort of this phrase that's a lot to unpack, so I'm going to break it down really easy here. It's a policy or a practice that seems completely neutral, but it impacts members of a protected class. So all three of these criteria, these three issues that we talked about, credit scores, eviction, and criminal records, are going to be issues that touch on protected class status, which then makes it a fair housing issue. So really, again, usually I don't get to talk about things like evictions or landlord-tenant screening. But when you look at credit, you look at eviction, you look at criminal records and source of income, which we talked about already, those topics do touch on protected class status. So there are things providers should be doing to screen applicants in a more equitable manner. Okay, so let's talk about credit history. So the use of credit history is, again, really a very, very common criteria when we look at tenant screening. Unfortunately, studies, and I can send out the report, it's actually at the link here in the slides. Numerous studies have indicated a huge level of racial disparity regarding credit scores and also what's known as credit invisibility. So people who just don't have a credit score at all. The issue has become that just a credit score actually does not capture whether or not somebody is going to be a good tenant or not. Because credit score doesn't include things like timely rent, utility payments, or bill payments. Credit scores also don't include timely payments to non-traditional lenders. Payday lenders, for example, are not captured in the use of a credit score. So really, credit score in and of itself has become a really poor measure. And so there was a question in the chat that was submitted earlier around FICO credit scores and the use of FICO credit scores. And I think that the use of credit scores has really something that HUD has certainly focused in on and has said basically, hey, try not to use just a credit score, but look at what is actually going on within the credit report. Because you may need to waive or adjust a credit screening because somebody also requires a disability. So there are reasonable accommodation requests that can be made as well. I think that was another example that came up, was around credit caused by a gap of loss, sorry, poor credit caused by a gap of time that goes on between payment with employment and when somebody receives their disability benefits. So that's related to a disability that impacts somebody's credit score. That could be a reasonable accommodation. No HUD program requires screening rental applicants for their credit score. Providers should always consider more than just credit score. And again, consider disregarding when credit history is not applicable or unlikely to occur again. The examples given here, voucher holders. So source of income, voucher recipients. Folks that receive vouchers are income qualified by the housing authority. So this credit check, this income check has oftentimes already been done by the housing authority. They have made that determination. So, for example, a voucher holder whose voucher covers the entirety of their rent and fees, their credit score is really not going to be applicable in that situation. Sometimes credit scores can be impacted by families or medical emergencies, or often due to someone being a survivor of domestic violence as well. And in all of those situations, HUD encourages providers to look at and disregard that credit history in those situations. We also always want to allow the applicant to correct false or inaccurate information, and again, to provide those mitigating circumstances as well. Yeah, credit scores, credit history, it's not always accurate. Heck, I just received the other day, I just received notice from one of the credit authorities about a settlement payment or the class action lawsuit because they were hacked and credit scores were changed. So again, it's that credit score really isn't so important, is what providers are saying. I would also add here, local areas do add and change credit laws sometimes, or laws regarding the use of credit. Again, Washington, D.C. has added certain protections regarding credit for all tenants, but also for voucher holders as well. And I would expect other jurisdictions to eventually do that as well. So I think really credit has become a big hot topic in the fair housing world. And I would just encourage the use of that individualized review and recognizing that credit score is perhaps not a great indicator of somebody's likelihood to be a good applicant or a good tenant. Another common measure is eviction history, the use of evictions to disqualify or approve someone from a housing opportunity. Again, eviction records are not always accurate. 22% of eviction records studied were found to be incomplete or inaccurate, so almost a quarter of eviction records in a national study weren't accurate. Evictions also, again, disproportionately impact people of color, families with children, and people with disabilities as well. So evictions are another example of a policy that, hey, it seems facially neutral. Follow these rules, follow these policies, and we won't evict you, etc. But when you actually look at the numbers, you look at the statistics, it does not end up being neutral. So it again impacts members of a protected class at a disproportionate rate. So again, providers should never rely on inaccurate or incomplete records. Providers should not deny an applicant based on really eviction history where the tenant prevailed, a settlement was reached, or the matter was dropped. Look at when the eviction occurred. Never evict survivors of domestic violence if that situation is directly causing their eviction. And also, again, be aware of when an eviction may be related to a disability, there could be a reasonable accommodation to be made. So, again, a couple of common themes here that we touched on already with credit, I think do apply here. So, for example, not always accurate. So, records aren't always accurate. We shouldn't be using eviction records after they're sealed. So, another example of this that's becoming local law, Washington, D.C. recently applied a 3-year look back window to sealed evictions. So Virginia does not specify that, but again, HUD is encouraging everybody to look at, well, when did that eviction actually occur? And maybe not be disqualifying someone because they got evicted 20 years ago. And also, again, allowing for any reasonable accommodation that may be related to that applicant's disability and why they were evicted. The third area that I want to touch on before we open it up for questions is incarceration and the use of criminal records checks when it comes to housing. This is another example, and this is perhaps the most famous example of that notion of disparate impact. If I go back to what impact looks like, policies, practices that seem facially neutral, but impact members of a protected class. And that's because, again, nationally, when we look at data, what you find is that the criminal justice system at every level has extremely high levels of bias towards people of color and people with disabilities. Ultimately, what that means is when these individuals have served their sentence, when they go to encounter or look for opportunities regarding education, housing, employment, they encounter collateral consequences of their incarceration. So HUD, again, in a number of different types of guidance, has really encouraged applicants to take what is known as an individualized approach or complete an individualized review of someone's criminal history. They were focused around two different things, and I'm not going to have time to cover the first one in depth here today, but HUD has been focused around two areas with regards to criminal records, which is discriminatory intent and discriminatory effects. Intent essentially refers to treating someone differently because of their protected class status. So a provider who rejects a black prospect because of their criminal record and allows a white prospect despite having that exact same criminal history. So you're treating someone differently because of their protected class. So when we look at intent, we actually did a big study into this a few years ago, and we found differences with regards to intent and the use of criminal records in about 35% of the tests that we completed. The ERC did over 50 tests in that study, so this is not an insignificant number. We had a really high difference in rates of different treatment. So again, treating people differently. The other area is sort of that reference to disparate impact. Treating or a policy that treats someone differently or has an impact on someone because of their protected class. The most common example, blanket bans. No felonies allowed. Again, that blanket ban, because of data, because of studies that we have seen, the demographics of incarceration, that blanket ban is going to impact people of color, people with disabilities at greater rates, even though there has never been any study that has indicated any population is any more or less likely to commit a crime. So again, I think HUD, what they've done really explicitly with criminal records, this can also sort of be applied, a lot of these themes, to credit, evictions, and income, is that individualized review. Whether or not an eviction occurred, whether, like for example here, an arrest does not mean anything. An arrest should never be used. So providers should only be using convictions. What type of crime occur? When did that crime occur? How long since that crime occurred? And again, looking at evidence of rehabilitation efforts and also this idea of reasonable accommodations as well. Is this conviction related to someone's disability? And then maybe we should change our policy for that individual as a reasonable accommodation. So it's not an accommodation of a conviction, but it is an accommodation of a disability by mitigating the effects of that conviction. So the common example there is somebody who has been arrested for some sort of drug usage, and they have served their sentence. They are in treatment. They're no longer actively using. They're disqualified from a housing opportunity because of their criminal history. Well, that could be, if that drug usage was related to a disability, something that could be reviewed as a reasonable accommodation. And that was just what that scenario was. So HUD has a few guidelines for people who do want to still run their criminal records checks. We want to have that written policy that is available to everyone. Ensure our policy protects resident safety or property. Ensures your policy considers what type of crime occurs and when did that crime occur. Be careful with third-party screening companies that use biased algorithms. Allow that applicant the opportunity to correct false or inaccurate information. Comply with local law. Make that conditional offer before extending or reviewing somebody's criminal records history. And then conduct that individualized review of any rehabilitation efforts. DPOR does have in Virginia a model policy for tenant screening. I can share that here. There's also a link to that on the last slide as well that will be dispersed to you. It does cover some brief guidelines for income credit screening. Really, it's providing that criteria up front. They use, or they recommend using, a 5-year look-back window that does not consider arrests, expunged convictions, etc. And again, using that individualized review. And that link will be in the slides given to you. But that's just what Virginia does recommend. DC does have their own local law as well. And so if you do work in DC, I do recommend that you change or look at those policies. All right, so a couple of overlapping best practices here, folks, that I want to make sure we have some time for questions. Always choose our relevant screening criteria that serves that legitimate business or safety purpose, whether it's credit, criminal background, eviction history, income, all of those. If they're overly broad, then they're not serving that legitimate business purpose, and they could be disqualifying members of a protected class. Use only accurate records. We talked about evictions, we talked about credit. Those reports are not always accurate. Give the applicant the opportunity to recommend or to correct false or inaccurate information. Always share all of your rental criteria with applicants ahead of accepting any fees or deposits. Ensure third-party screening companies are aware of local laws. And again, allow that applicant the ability to correct false or inaccurate information. So with that, we have some time left here for questions. Thank you, everyone. I know we just covered a lot of ground there really quickly, and I'm happy to answer any questions around anything I talked about, any other fair housing questions as well. And I'm going to scroll through the chat here and take a look as well. And I know Jill is going to tee up a couple questions.
Yeah, thank you, Brian. That was amazing. There's so much information, I think, misunderstanding. So really appreciate you trying to kind of clarify some of the rules and best practices as well. Candace from Prince William County had a question about seeing property managers excessively charging voucher holders security deposits more than 2 to 3 times the full rent, not their portion. And does that violate source of funds protections?
Yeah, so in my opinion, and again, I cannot offer legal advice, so I do want to provide that disclaimer here. Where somebody is applying to, so source of funds essentially refers to treating someone differently because of their legal source of funds. So in my opinion, if you are changing the deposit amount because of someone's source of income or source of funds, that provider is opening the door to a potential violation, and we would probably flag that in one of our tests, because I did see another question about testing in Virginia. Yes, we have a couple of great fair housing organizations in Virginia, the Equal Rights Center up here, and Southern Virginia has their own fair housing agency as well. And both of those agencies do testing throughout our area around source of income. And so we are testing to make sure landlords are accepting vouchers and in compliance with local laws all the time.
Wonderful, thank you. A question from Jeannie with Department of Behavioral Health and Disability Services that her agent sees many people with disabilities who, due to their Social Security incomes and or the court taking away their ability to manage their funds, they have no credit history. They are being charged higher security deposits even though they are unable to build credit. Is this discriminatory in your opinion, and what are their options?
I would have them contact our agency because, in my opinion, yes, absolutely. Again, somebody changing now, a landlord can vary the security deposit. In my opinion, if you are varying the security deposit and it is related to somebody's disability, that individual has a right to a reasonable accommodation that would be, in that case, not increasing their security deposit because of their disability. I think, for example, that guidance from HUD that we covered today actually provided a really great example of the applicant who is receiving disability benefits, and there's a gap in payment from their employment to when they receive the disability benefits. So they may have a lower credit score. If you're increasing their deposit because of their lower credit score and it's related to their disability, I think you would want to be really careful about doing that.
Great, thank you, Brian. Is anybody pushing HUD guidelines to the low-income housing tax credit property managers? And is there ways to recommend that they comply even if they don't have to? If there's
Um, I think this one is actually a lot more complex than we're going to have time for here today. I do want to say, though, that sort of the LIHTC properties are certainly subject to fair housing laws, and the Fair Housing Act does still apply. Now, there is various types of funding that can make some of the tenant screening portion of that a little trickier. I know some properties, for example, do have their own tenant screening criteria that they should be making available to the general public, etc. So also sometimes local areas add requirements for tenant screening. So I can't speak too specifically, but I would say uh, that any of the LIHTC properties should at least at the bare minimum, be making sure their screening complies with their funding regulations, their local regulations as well, if necessary. And then more broadly speaking, again, fair housing does still apply.
great, thank you. And if someone's found to be in violation of the fair housing laws, what are the consequences that they might face by the landlord or the agency, and remedies for the tenant, if any?
That can be a really broad spectrum, I would say. And I've seen cases, from the result being, so you know what? Actually, let me approach that from a different angle. So the Equal Rights Center, our goal when we have somebody contact our agency and somebody says that they've been discriminated against, first, we're going to investigate that claim, and we also want that applicant or that prospect in most cases, we want to be advocating for that prospect to get whatever opportunity they were looking for. So oftentimes, our first course of action is we want to get that individual into that unit that they are qualified for. So if they're disqualified for a discriminatory reason and they still want that unit, that's what we're going to advocate for. Of course, there are larger consequences in some more significant cases. You do have cases that go through uh, the complaint process. This can take place at the county level. It can take place at the state level. It could take place at HUD. And so there are sort of all sorts of resolutions to um, the complaint process. Some can be financial. I'll say also for the Equal Rights Center, what we will always argue for as well as part of any of the settlements that we may engage in or any of these discussions is we want to increase education and we want increased compliance with fair housing. And so really, those are our two big areas are what does our client want? What housing opportunities do they want access to that they're qualified for? And how can we increase compliance with fair housing down the road from that housing provider to make sure that they're not discriminating later on as well?
Excellent. Thank you. And one more question before we go. What does the new administration have to do to repeal HUD guidance, or can they repeal HUD guidance? Do you know?
Gosh. Hillary knows all about affirmatively furthering fair housing. Yeah, no. So
Well, yes,
I was
that's
just
a whole different webinar. We can go into the history of what happened in 2018 and when the rule was replaced with that administrative guidance.
Mhm.
Yes,
Yeah,
sorry.
so I mean, there, unfortunately, like with affirmatively furthering, there's also been guidance around housing and emergency shelters and a couple of other rules that, I started doing fair housing work in 2012, and yeah, I've already seen I've seen a lot of these policies really boomerang back and forth from administration to administration, and and that's another reason, though, why local government is so important. That's, the regional impediment to fair housing, all of that sort of thing, and are just the regional approach is really important because local governments do play a huge role in building those coalitions to make sure that those changes, maybe at the federal level, aren't so impactful to changes in our region.
That is a perfect way to end this session. So thank you so much for your wisdom, Brian, Hillary, for framing the importance of this issue for all of us. Kudos to you both on the hard work that you're doing here at the regional level, of course. You will get contact information for Brian sent out in the slides and the recording, and we hope you will join us next month. So thank you all for being here. Take care.